Wenn ein Mensch kommt auf mit einem frischen Produkt, eine Idee oder ein Business-Konzept und will nicht andere Menschen sollen ihm noch machen, hat bereit, sie feilen für ein Patent und der Government legt darauf ein Verbot auf andere Menschen noch zu machen sein Gedanke für 20 Jahre. Ob einer hat ja der Gitzbus noch zu machen, kann man im Brief in den Korten suchen. Deze alles wird arrangiert durch ein Patent Lawyer in Hand haben und so auf dem Telefon ein langjähriger Attorney, was hat schon gleich 150 Patents auf gut interessante Ideas, der Moshe Feigi und viele von der Law Firm of Michael Feigi. Die Interview nehmen wir 25 Minuten. Der Moshe, Shalom Aleichem, how are you?
Hi, Shalom Aleichem, very good.
It's an honor to talk to you. I know you're a busy man, so thank you for taking off from your time and to educate a little bit Kolmavasa listeners about patents. So first of all, let's talk, as you say in Yiddush, Kleingeld. Small money, let's talk a little bit. What do you do at your law firm?
So I do intellectual property, which comprises patents, trademarks, and copyrights. That's primarily obtaining patents, trademarks, and copyrights for clients, as well as licensing agreements and forming corporations and that sort of thing. But the main thing would be, most of it is you have a concept you want to protect, you have a new business, you protect that with a patent, you protect the name of the business and your logos with a trademark, and so forth.
So you do patents all day, but our listeners only hear about it once in a lifetime or whenever they have to get a patent. So can you explain what does a patent mean?
Sure. A patent means that you have some new technology, something new that you've created, and you want to be the only one to sell it. You file a patent with the United States government, and you basically use the power of that government and the power of the court systems to say that no one else can make, use, sell, or import that concept which you've protected with a patent. So you get a monopoly over it for usually 20 years.
And after 20 years, you can renew it?
No, after 20 years is public domain for it, then anyone can use it.
That's interesting. So a patent basically is for 20 years, it's protected. After 20 years, it's free fall to do the same type of technology.
Yes, because the reason, this is in the United States Constitution, and the reason it's there is they want people to develop new technology. They want to have new and better and come out all the time. So they give you an incentive. They say, tell us exactly how to do it. How do you carry this out? And in exchange for publicizing this to the world, how you do something, they're going to say, okay, we're going to say only you can use it for 20 years.
But the downside is that basically someone invents a new technology which is complicated. Not anyone on the street can duplicate it or do the same thing. So he takes the risk that after 20 years, every Joe on the street just looks it up and does the same exact thing without using his brains even.
It's true, but the reality of the situation is most things that are coming out today, a person could reverse engineer, a person could copy it. You sell a product on the market that's patented, then they're going to be able to see what that product is and copy it. So without the patent, they're going to be able to do it right away as opposed to do it in 20 years.
Right. So people patent ideas. You said that no one should be able to do the same type of an idea, and they make money for this 20 years. Do people also patent ideas, and they don't mass produce it? They just wait someone to copy it, and then they can sue them and make a lot of money?
Yeah, that's also possible. That's what the secular media calls a patent troll. I don't know how you say troll in Yiddish, but a troll is someone that they obtain patents just for the purpose of suing other people. Which is also, the fact is if you have a patent, it's your property, and someone is using it, that's infringement. It can be. If it's a legitimate patent, that could be a legitimate business too. You can also get a patent even if you can't sell it. You license it to another company. You license it to a company which can go and make it, is going to find it useful, and you get a royalty from them.
Because suing is in the headlines now since Donald Trump is running for president, and he is the king of lawsuits. What would you say? Is it more money making or headache free to just keep the patent and sue everyone, or produce it or license it out and make your royalties?
It depends what it is. It depends what the technology is. If it's something for a new kind of car, you're probably going to license that. If it's for I don't know what, something smaller, we say it's an app for an iPhone, then that's the type of thing that you can go and protect and make the app yourself and do it. And if you make it yourself, you get 100% of the profits, whereas if you license to someone else, you typically only get 6 to 10%.
So we spoke about patents, and you mentioned before trademarks and copyright. What's the difference between all this? Can you explain trademarks and copyright?
Sure. So a trademark protects your name or your logo. So example might be art scroll. No one can come out, aside from the halakhic problems in secular law, no one can come out and start selling books under the name art scroll because they have a registered trademark, and that would be infringement. Meanwhile, they might have the symbol, their art scroll logo, so you can't use their sell books or similar goods using that logo. That's theirs and only theirs, so that you know when you pick up a book and it says art scroll, you know where it's coming from. Whether you like art scroll or don't like art scroll, the fact is you know it's coming from this company that sells only art scroll, and it's not coming from anywhere else.
That's a trademark and a copyright as well?
So a copyright protects works of art or any artistic creation. So, if you have, say, a painting is the classic example. You have a photograph. You take a photo of the Rebbe and you file a copyright. And no one else can be selling that photo. That's now copyright infringement. Or your instructions for a game, or your literature, your pamphlets. Those sort of things, they can all be protected by copyright, so that only you can use them.
So Moshe, you have been a patent attorney for years now. What type of patents do people typically make? What did you experience during your career? What type of patents? Just an example, people should understand.
All sorts of things. So there is popular right now is to do phone applications, the things that are being done differently with, say, like Uber with ordering a taxi. People are filing things like that, not for taxis, obviously. It has to be something new. Or they have mechanical products. You have types of whatever it is, connectors, games, equipment that's construction equipment and things used in construction of buildings. I have medical devices. So people selling medical supplies. Look, I have new variations on the medical products. Let's see, what other categories? There's electrical, way circuits function, and any of these types of things are categories where you can protect with a patent.
I got the idea, but you mentioned iPhone apps or softwares.
Yeah.
Does the patent apply on the back end, the coding, or the front end, the look of it, the user experience of it?
Well, the back end, the coding would be protected by a copyright. As well as the look of it, the user interface could also be protected by a copyright. The name of the app would be a trademark. So, for example, I have a client, he sells spoof card. It's to change the caller ID, so he's got a copyright on the look. His spoof card, he has the name and the logo for spoof card is protected with the trademark, and he has a patent on the concept of using this system to change your caller ID on the remote system. So then that's patented. So all three can apply.
Okay, so someone has an idea. He thinks it's, of course, a genius idea because he thought about it. So at what point does he involve your firm to help him with the idea?
So sooner rather than later. Patents should be filed before you go public with them. And sometimes you can do it after, but only, but not in other countries if they want to go other countries. But basically, you want to do it first and see what's protectable before you move too far on it.
Mm-hmm. And when someone has an idea, he usually likes to talk to family and friends about it. Is that a good idea, or they can take it because it's not patent yet?
It's not a good idea. The best idea is don't tell anyone anything until you need to.
Okay, so let's say he meets you. What would be your initial conversation with him, and what would you do from there? How would you take it from there?
Sure. So initial conversation is usually the person will come in for a consultation and show me what you have. Sometimes it's you have something written. Sometimes you just want to sit and talk. Sometimes you have a prototype, some sort of product to show me, and I'll take a look at it and understand it. And then once I understand it, then we'll talk about what's the name of this thing, can we protect it with a trademark, and what are you doing with it, and something potentially protectable by a patent, it's a new invention, then we do a search. It takes a couple weeks. I find the closest patents that I can at the patent office and what features are shown and not shown, and I give a written opinion saying, this is what I think we can claim, this is how I searched it, this is what features of that claim are shown here in this reference and that reference, and in order to determine what can be protected. And then if that's good, then we go forward with a patent application. At that point, it's patent pending, and you're on your way.
Mm-hmm. How long does the process take until you get a patent?
So process will take, your regular process usually takes about 3 years. There's also expedited filing. You pay the U.S. Patent Office extra money. It's supposed to take 1 year.
So patent pending is basically until you get your actual patent. Does patent pending have any security, any strength?
Yeah, you have a filing date, and you can put patent pending on your products and tell people it's good for marketing, and it's good for also telling people that you plan to have a patent on this, so they should be careful and stay away.
Mm. But when it's patent pending, it can technically fall through as well, no?
It can, yeah. There's no guarantees. I mean, even if once you have a patent issued, it could always you still have to sue, and you have to go through the court and so forth. But it's definitely a scary thing, and it adds a huge hurdle for people who want to copy you, because they know you can take them to court. It could cost them a lot of money.
Hmm. Let me ask you a question, Moshe. You are a very honest Yid and an honest businessman, but I'm talking about other attorneys that do the same type of work. How can someone be sure that the attorney won't take his same idea and patent it himself or sell it to someone?
Well, it's like the same way you find anyone reputable. How do you know when you hire an electrician? How do you know that he's going to do a good job? You know, he's someone who's been doing it for a while. He comes from recommendations, and you can see the amount of work he's done. I've done. You can see on my website, I have listed every patent I have issued. I have about 150 patents, and I have a duty of confidentiality. Anytime a client comes to me, I have to keep it confidential. It wouldn't make sense for me to go and now I'm going to take someone's idea and I'm going to destroy my own business over it, and lose my license and fine and everything else. It's simply not in my interest to do so. My interest is in getting you a patent. That's what I want to do, and that's what I like to do. It
might work once or twice, but not for 150 patents.
Right.
You don't have to give me an exact number, but typically, how much does the whole patent process run?
It very much depends. Design patents, they start about $2,000. Utility patents start about $6,000.
What's the difference between a design and a utility patent?
Sure. So up till now, we've been talking about utility patent. That protects how something functions. You have some new way in which something works. A design patent protects the look of the object. So many people, for example, import products from China, or get the products made in China and import it, and then what happens in China, they just go and knock it off and sell it to 50 other people. So you file a design patent, and you can stop them from selling knockoffs of your product. or something you're selling on Amazon, again, same thing. You can sell on Amazon or eBay, and whatever the product is, it could be something people are already selling. I mean, people are selling shelves. A client who is selling a certain type of metal racks, that these type of things, that his metal rack looks different, so you do a design patent, and then that way a person can't sell that one. They have to sell a different one.
Right, but if someone files only a design patent, let's say someone has a new type of shampoo, he only files a design patent on his bottle because it's a unique look. Someone can put the same shampoo in a different bottle and sell it then.
Right, because the shampoo itself, well, when we can talk about shampoo, the bottle, it would be protectable by a design patent. The brand of the shampoo would be protectable by a trademark. The actual contents, shampoo, it could be that the shampoo is whatever, it's the same shampoo everyone else is selling. Then that's nothing. You're protected by the trademark in the bottle. You're protected by the marketing and the look of the product, and those things are more important. But if you had, say, a new formulation of the shampoo, you were putting some new ingredient in there or making it in some different way, it might be possible to patent that.
So now, if someone finds out that a company violated his patent, would you go and represent him and fight for him?
You can take them to court. So you start with writing them and you demand they stop selling or demand damages, and if you have to, you can take them to court.
But would you be the one that fights for your clients, or you refer him to a different attorney?
So that I work with. There's other attorneys I work with for that, because I don't personally litigate, but I have attorneys I work with to do it.
So it looks, if someone has an idea, but to develop the idea it costs a lot of money. He doesn't have that money. Is there any way to come to you, patent idea, and then find a way to make money off it without investing a lot?
Well, not really. It costs money. I've found a lot of people will find friends and family to help with the investment, but no, I mean it is an expense, and if you're starting up a business, it's one of many business expenses, and it won't cost, and it's nothing compared to if you have to warehouse a product or pay for a programmer or pay for marketing and that type of thing. This is just one expense, which is certainly not the largest in starting up a business.
Right. Or then the cheaper way out probably would be licensing, but it's also some investments, I guess.
Yeah, it's also still usually some investment. Put it this way, the more you're willing to put into it in time and energy and money, the better deal you're going to get from then selling it to somebody else. So in other words, if you have, at the extreme end, you file just a very basic, what's called a provisional patent application, which gets you some protection, and then within 1 year you have to pay the money to do the full application anyway, and you have not started the business or anything, you're not going to get nearly as good a deal, say, as in the other end, where you filed the patent, you have the product on the market, you're selling it, and you're making a profit. Now you have a business that instead of something which was worth, you get 1% or 2% from somebody of something that may or may not happen, you have a business that maybe you're making $1 million a year, and now you can sell the business for $10 million.
Right. If someone comes to you with an idea and you see this idea won't fly, it's not a good idea, he won't make money off it, would you advise him, or you don't take the role of an advisor?
Yeah, no, of course, I'm happy to advise.
So how would you see if the idea is good or bad? Is that?
So my expertise is in intellectual property. So, and I'm able to tell you, is this going to get through? Is this not? How good of protection are you likely able to get? That I'm happy to say. In terms of marketing, I can't say my expertise is in marketing, but I've done enough of this. I've seen enough products that I can give you some idea of like how much it's going to cost you to manufacture this thing, how much are you likely to be able to sell it for, and if need be, I send you to a marketing person. I send you to I'd send you to somebody like Joel Klein, who referred you to me.
Moshe, you're a patent attorney. You could have gone into any line of business, even in the attorney line. You could have been any sort of attorney? Why did you choose patent?
Well, the truth is, I was looking to go to medical school, and I became a Baal Tshuva, and I realized I could go to yeshiva for a few years, and I could go to law school, and I could still come out with a parnasa much sooner than if I hadn't gone to yeshiva and went to medical school.
That's a short answer, but this, in the patent world, you see every day, you see different types of ideas. If you have to put yourself in a different type of mechanics, isn't that a hard thing?
Yeah, it's well, I don't know, it's hard. It's challenging. It keeps your mind going. Every day I'm working on a different type of technology, and I find it very exciting that there's always something different, a different aspect of the world, a different aspect of the of the Bria that I'm understanding more of. And I'm dealing with people, so I'm dealing directly with people every day, and I'm very science and math oriented. So I find that I very much enjoy what I do because I get to work on things that I find interesting, and I get to have daily interactions with the people who are coming up with it, and at least to me it's very exciting.
Very interesting. If someone searches the web or looks around, there's a handful of patent attorneys. Why would you feel someone should come to you and someone will have a better experience by you over someone else?
Well, if they call me, I'm going to answer my phone and I'm going to talk to them. I'm going to answer their questions. I'm very experienced. I have a lot of work, and we're a two-person law firm. It's just my partner and I. And I like it that way. I like being able to do this, so I have the direct client interactions and directly work on what people give me. And you get high quality work, and you get good, and you also get good service. There's an issue, there's something you want to talk about, you call, and I answer my own phone.
Do you, as a patent attorney, do you have any patents yourself?
No, I've only filed them for other people.
Okay. Let me ask you my last question.
One of my clients is actually my brother's company, so it's not my patents, but I've filed about 5 for my brother at this point, which I've issued.
That's interesting. So you speak a lot at the SCORE workshops, and you talk to young entrepreneurs. We have a lot of young business people listening to this interview. What could you tell them, any piece of advice for someone just starting out in the business world?
Sure. Give me a second, I'm sorry.
No problem.
So I guess I would tell them is the main thing is to get educated. The main thing is, and one of the best ways to do that is talk to people who have done it before. There's a lot of people who have gone through the process of starting a business, and there's a lot of people, and most of these people, or most people I find in general, are very willing to share the information. There's a lot of people you call up and you say, I'm not looking for anything from you, but just some help. I just want some advice. I just want you to tell me your story. Tell me about yourself. Tell me how you got to where you are. And what steps do I take to do that? Because, for example, in my own practice, I can tell other patent attorneys how to start a business. I can tell other people. I've told people all the time. This is another part of the advice: is give Meiser, and give Meiser not for the income you have, but for the income you want, and Hashem will take care of the rest. And I've told that to many people, and nobody listens anyway. So, you can talk to people, and as long as you're that one person who's willing to listen and follow through, and it takes hard work and effort, and even something as giving Meiser is hard to do. It's hard to give, more than you think you quote unquote have to. In the same way, Hashem will treat you that way. Hashem will give you more than you quote unquote has to also. So, and as part of getting educated, I have lots of information on my website. I explain the whole process, going through the patent process and the trademark process of how you go from beginning to end. And it's just, I feel it's important to put that information out there. And then A lot of people don't read it, but those who do, they come in, they meet with me, they know a lot about the process already, and then we get started, and we can move so much quicker.
Right. Fine. Moshe, thank you so much for your time, and look it up.